What comes to mind when you hear the terms liquidator and receiver? Hi, I'm Simon Dippenaar and I'm a family lawyer. Receivers and liquidators are more commonly associated with corporate failure. A liquidator is someone legally empowered to wind up a company's affairs when it is closing, typically when it's going bankrupt. A receiver is appointed to be a custodian of the property, finances, and general assets or business operations of a company going through financial difficulties. A company in receivership may wind up going out of business, or it may be sold off or restructured. You may wonder why a family lawyer is discussing this. What does this have to do with divorce? Well, in a sense, a divorce is a marriage going out of business. It's in liquidation. Divorce proceedings often cause financial disputes, especially when it comes to dividing shared assets. When divorcing couples cannot agree on how to split their assets, a court may appoint a neutral third party, a receiver or a liquidator, to oversee, manage or distribute assets in contentious divorce cases. This step can ensure fairness, but it also has potential downsides. The liquidator is responsible for winding up the couple's estate, just as a corporate liquidator winds up a company. Their duties include identifying assets. They locate all assets, including properties, vehicles, investments, and other valuables. They value assets. They assess the fair market value of these assets. They sell assets. The liquidator organizes the sale of certain assets, if necessary, through auctions, private sales, or other means. This may be necessary if a couple owns intangible assets, such as artwork, and can't agree on a fair division. Distributing proceeds. They ensure proceeds from asset sales are distributed fairly, as indicated by the divorce settlement or court order. By contrast, a receiver manages and protects assets until they are officially divided. Their responsibilities include securing assets. They take control of assets to prevent misuse, waste, or loss. Managing assets. They oversee day-to-day management of properties, businesses, or investments to maintain or enhance their value. Protecting assets. The receiver implements safeguards such as insurance, security, and maintenance to prevent depreciation. Facilitating distribution. They prepare assets for final division according to the court's decision or divorce agreement. Their functions are similar, but liquidators focus on finalizing estate matters, whereas receivers manage and protect assets during the divorce process. The advantage of using a receiver or liquidator is impartiality. They divide assets according to legal agreements, reducing the risk of bias or unfair advantage. They prevent asset concealment or misuse, which may occur in high-conflict divorces. A receiver ensures assets are secured and preserved. They can also speed up the divorce process by reducing delays. This can also keep legal costs down. For divorcing spouses with joint business interests, a receiver can ensure continued operation until a fair division is reached. If a party fails to comply with the divorce settlement, a receiver has legal authority to execute asset division in line with the court's decision. However, there are some disadvantages. Receivers and liquidators charge fees for their services, which may reduce the overall estate value available for division. Once a receiver or liquidator is appointed, both spouses lose direct control over assets, which can be frustrating, especially if they disagree with the receiver's decisions. The receiver's powers depend on the scope outlined in the court order, which may restrict their ability to resolve all the disputes effectively. In many cases, divorcing spouses can resolve disputes through mediation or negotiation, making the appointment of a receiver unnecessary and saving cost. Appointing a receiver or liquidator can be beneficial when dealing with complex assets, business interests, or an uncooperative spouse. But at SD Law, we have always championed a mediated solution. Alternative dispute resolution methods should always be exhausted before resorting to measures such as the appointment of a liquidator and/or receiver. At my firm, SD Law, we have a track record of facilitating mediated divorce, even in high conflict situations. A mediated settlement allows both parties to walk away with their dignity intact and move on to the next phase of their lives. If you are considering divorce and want to discuss your options, please contact me or my team on the number below for a confidential discussion.